Simulations also, the way I set them up is I just set up a scenario. They're semester-long simulations, they're incredibly complex, and no class goes the same way. I am often in the position of actually being a knower, because a lot of times questions come up that I quite frankly do not know the answer to. And what happens in that situation, I get to model for the students how a professional who does not know the answer to something goes about figuring it out. When I was in law school, that never happened once. When I became a lawyer, I realized it would have been nice if I had somebody model in a situation where they didn't know the answer. So in my upper class courses, I'm trying to achieve what Parker Palmer calls the community of truth, and what David Schwartz would term the professional model, more of the professional model. At the Stern College of Law, we're pioneering a series of courses, and this is sort of taking what I've just shown you about simulations, but also the apprenticeships and the Carnegie reports. You can't see probably what's up here because it's too small, but I'll just read it to you. The courses that we are calling Carnegie integrated courses meet the following requirements. Number one, a substantial and regular component, which is at least 2 of the following practice contexts in the class. 1, litigation. 2, contract agreement or drafting, negotiation, client and or witness interviewing, client counseling, ADR, legislative drafting, oral presentation. At least 2 of those to qualify as a Carnegie integrated course. Obviously simulations are best adapted for meeting more than one of these requirements. B, writing and research skills. Students will write several legal documents, and students will write a variety of documents, including e.g. briefs, motions, reports, legislation, internal memos, reflection papers, etc. 3, students will write at least 1 document with requirement of a rewrite after feedback is provided, and students will research at least 1 legal topic posed by and related to the simulation or practice context of the course. Then there are 2 minor requirements. 1 is professional identity, ethics, and values. In addition to exhibiting professional behaviors throughout the course as well as in simulated practice settings, including collaborative groups, students will be required to submit at least 1 graded assignment concerning ethical and or professional identity issues posed by and related to the simulation or practice context of the course. Our feeling is the best way to get our faculty as a whole moving in the direction of professional identity formation is to require graded exercises in class around any issue. It could be the smallest ethical rule, it could be the broadest moral question. Our idea is that if we get the faculty in the practice of doing that, even if they start with small ethical rules, they'll move toward the other, and I explained that earlier in the session. The idea of a graded assignment is this idea of intentionality. We know professors do come up with situations in regular doctrinal classes where there's a question of, ethics or morals, and those get handled in the class. We thought, though, that if we required graded exercises in these integrated courses, that they would be much more intentional about the assignment. The professor themselves would think about the context more and would probably come up with more appropriate and deeper scaffolding around this issue. So it's our way of sort of seeding this in the faculty. And then finally, B, oral presentation or advocacy. In addition to regular participation in the class, students will be required to prepare at least 1 graded oral presentation on an issue or issue posed by and related to the simulation or practice context of the course. That's a lot of stuff. I worked with a committee which represented all the heads of all the departments and programs in the law school, and we came up with this. We went then to our community professors to find out who was doing already something close to this, and we found 25 courses where people were doing not all of this necessarily, but pretty close to this. And guess what? Quite a lot of those courses were taught by adjuncts. Very interesting. And it makes sense. Adjuncts come in here, they're in the practice of law. They know what our students need, really. They're on the ground. A lot of people look at those requirements and say there are a lot. We have done some things in the school to make sure that professors have time and or monetary incentives to retool courses. So we're working to expand what we call Carnegie Integrated Course. And by the way, this is moving, and this could change. We have changed some of the requirements for a long document, for example. We took that out already. I'm going to talk about two of my courses that meet the Carnegie integrated course requirements. The first is labor law. In the labor law class, very quickly, I allow the students to organize if they want and form a union, vote in a union, and then bargain with me about the terms and conditions of the class, which includes everything, how participation is handled, what material we'll cover for the rest of the class. An employer cannot unilaterally implement anything that's really important.
They now shake their grades.
Yeah. And so I'll tell you real quickly, despite all the research on simulations, which I've later found out about, I started this in 1993, and it was necessity is the mother of invention. I came to a school where nobody even had heard about unions. Union density in the state is 2%. And so a lot of the cases, which were like from out of Detroit and blue-collar models, the students just couldn't get to a lot of the material that was embedded in the cases about the dynamics of the employer relationship. So I thought, how can I get them the experience? Well, the classroom's kind of like a workplace. I'm the boss. I tell them what to do. Their pay is a grade, I suppose. And you know, they're even more deferential to professors than they are to their employers. So I thought the model would work, and it has. I just want to show you a little bit of how the course is set up. Before they come to class, I put up a no solicitation distribution rule, which tells them, you know, only charities can solicit in this class and nobody else can. They haven't even read the material around the legality of this. They don't get to that until 3 or 4 weeks later. So students are pretty technology oriented, so they're looking at this, they're reading it. Some ask me questions about them, and I say, remember, the workplace, this is like the workplace. This is the analogy, and so you'll figure it out. What happens is they have to pay attention to who's writing stuff up on the board. Does the Student Bar Association come and announce stuff? Because later, if they want to solicit in the class, they're going to have to show that I let other people in, that I violated my own rule. So the class starts that way. I give them 1/3 of the syllabus. I only start with the material on how to organize a union. And I say, union election, question mark. And I tell them, if there's going to be a union election in this class, that's not me bringing in the materials. That's you figuring out how to make it happen. And so the students start to read the cases and they start to see the analogy between the class and the workplace. I like the class too because I guess in terms of the analytics, it's a double transfer. They have to analogize to the classroom, which does not exactly analogize to the workplace. They have to figure out the analogy and then apply the case law to the simulation. So they're doing a double transfer of material, which I really like.